Now, let us move into this topic, an important one for sure, because it's having more and more impact across the country. Discrimination by any other name. In the wake of the U.S. Supreme Court's ruling striking down affirmative action in college admissions, a San Antonio-based government program that allegedly uses race-based preferences to hand out federal grants faces a federal discrimination lawsuit. That complaint, filed by the Wisconsin Institute for Law and Liberty, otherwise known as WIL, could spark a national re-examination of such taxpayer-funded, race-focused initiatives. WIL's Deputy Counsel Dan Lennington joins us now to discuss. Dan, sir, how are you? Are you there, sir?
Yes, I am. Thanks for having me.
Sorry about that. Just a little technical error. Absolutely. For full disclosure, I will note this. Dan Lennington is an exceptional attorney. I've known him for some time, and I've known the folks at the Wisconsin Institute for Law and Liberty. I am also a plaintiff in a lawsuit that Dan is serving as lead legal counsel on, a lawsuit against the Federal Bureau of Investigation. That's a different subject altogether, but it involves the FBI's, from our point of view, their failure to release critical information in a mass shooting at a Tennessee Christian school that occurred in March of this year. Perhaps if we have some time, we'll delve into that. But right now, this particular lawsuit, and I wanted to have you on because this isn't just San Antonio. This isn't just this particular case. The Wisconsin Institute for Law and Liberty and some other legal groups out there have been fighting the good fight about what some call reverse discrimination. But again, discrimination by any other name is discrimination.
Yeah, that's right. The Supreme Court a few weeks ago now struck down Harvard's affirmative action program, as most people probably know. That's sort of the headline, but really the subtext is that this decision it really laid out the law in a very, very broad sense to say that governments and private businesses, Harvard's a private college, by the way, must treat everyone equally without regard to their race. Everyone must be equal. You don't get any preference or priority because of the color of your skin, and that's federal law and that's constitutional law. So there's a kind of a head-scratching moment that happened after this decision came out. A lot of people started to call us and say, well, wait a minute. What about all these diversity programs? What about these other affirmative action programs? What about when my boss says that we do this because of equity? And our response has been, all that is out the window. Anything where there's a distinction based on race is unconstitutional. And so we had filed a lawsuit just a week or so ago against San Antonio for a grant program that was supposed to hand out COVID relief funds, but it gave priority to certain minority-owned businesses. That's illegal. Just yesterday, the Small Business Administration had a massive program called the 8A program, which some of your listeners may know about, was struck down by a court in Tennessee. And so really the floodgates have opened, and it's starting to open people's eyes about what's going on in other states and other places around the country that could be subject to lawsuits now.
Absolutely. We're talking with Dan Lennington, Deputy Counsel at the Wisconsin Institute for Law and Liberty. WIL is leading this lawsuit in San Antonio. But as I said before, this isn't just a Texas matter. But as we focus on the Texas matter, this is all about a small business that was eligible for it was millions of dollars, $10 million in total grants. They were looking at a $50,000 grant. This is money that is coming from federal taxpayers through one of the COVID relief programs, the American Rescue Plan Act. And they find out they're not eligible for this, or they didn't make the cut, not because they didn't meet all the other requirements, but because the owner is white. But because there is a methodology that they use, a point system, and they award more points to minority-owned businesses than they do for businesses owned by non-minorities. And that seems to be a problem in San Antonio, but it also could very well be a problem in Iowa, the Midwest, and elsewhere, I know.
Yes, we've looked at programs. We started by looking in Wisconsin, found a number of programs, but we've just today done some research about Iowa. Iowa has a number of race-based programs that are subject to litigation now, and I think the plaintiffs' attorneys are going to be licking their chops looking at these things, like the program in San Antonio. The Economic Development Authority there in Iowa runs something called the Targeted Small Business Program, and guess who it's targeted towards? Non-white employers, non-white businesses. You get special contracting, special loans, promotional opportunities to those businesses based on race. That's unconstitutional. The University of Iowa and the whole educational system in Iowa has a number of race-based programs. There are minority scholarships at Iowa called the Image Scholarship, exclusively for minorities. There's something called the Academic Incentives Minorities Programs, which is for community colleges in Iowa. That's race-based. That's illegal. Iowa also sort of famously has segregated spaces on campus called, quote, cultural centers, where they exclude people based on race. And, of course, they have their graduation ceremonies exclusively for minorities, where whites are excluded from graduation ceremonies. Those are called, quote, celebrations.
How far have we come in this country, Dan, where we're now segregating once again? That's something we had fought for years to get rid of, and now woke society is bringing us back to that moment. I just have a couple of minutes left. I guess I wanted to drive home this point. You mentioned all of these particular instances in Iowa that could face discrimination lawsuits, but let me play devil's advocate for a moment. We've heard this with affirmative action for years. We were not, according to the proponents of affirmative action, we haven't caught up. That is, their argument is there still is systemic racism. There are still so many obstacles in the way of minorities, and it's only fair to give them some preferential treatment in all of this. How do you feel about that?
Well, you don't have to listen to me. The Supreme Court confronted that head on. The Supreme Court decision, it says eliminating racial discrimination means eliminating all of it.
Yep.
In other words, you can't discriminate your way out of whatever systemic barriers occur. You can't discriminate against a white farmer in western Iowa, which, for example, we had a client from western Iowa who's discriminated against the Biden administration.
You bet.
Based on race. You can't discriminate against that farmer to try to help somebody whose grandparents or great-grandparents were disadvantaged because of Jim Crow. That's not the way it works. People need to be treated as individuals, and that's the only way our American system is going to work. It's a system based on equality and not based on discrimination based on your skin color.
All right, final question for you, 30 seconds left. The Supreme Court knows that. I think reasonable human beings know that, yet we have these government agencies across the state of Iowa and the country that are fighting that tooth and nail. Where do you see all of this going?
Well, I say, number one, legislatures and governors have got to get involved. Your governor, Governor Reynolds, you have a great governor. She runs this, Department of Health Services has got a number of programs. She needs to take some leadership on this. And there's a legislature there that needs to take some action. But if the legislature and the governor can't do it, we're going to have to go into court. And that's going to mean judgments against these agencies. And that means the taxpayers are going to be ultimately on the hook. So if you don't like paying higher taxes, based on these lawsuits, you should talk to your elected officials and make your laws colorblind and not race-based in Iowa.
Well, what is right, and eventually maybe the taxpayer is going to have to feel that coming up. It can stop right now, as a matter of fact. You can learn by what's going on out there, but lessons are hard learned, hard fought. Thanks for your time, sir. I appreciate it.
Thanks for having me.
You bet. Dan Lennington is Will's deputy counsel. They are the Wisconsin Institute for Law and Liberty, and they are taking on a number of these cases. The latest is in San Antonio. I wouldn't be surprised if another one comes up in Iowa for that firm or for others. We'll continue to monitor this because, again, discrimination by any other name remains discrimination.